This is LXBN TV, and I'm Colin O'Keefe. On December 6, 2012, Washington Initiative 502 will go into effect, making possession of marijuana completely legal in Washington state. Joining me now to discuss what the law means for employers is Seattle attorney Jim Shore of Stoel, Rives, and their blog, Stoel, Rives, World of Employment. Jim, what impact does Washington's legalization of marijuana have on the workplace?
Well, thank you for inviting me, Colin. And once you clear up the smoke, so to speak, the answer is not really any different than before the passage of the law if an employer doesn't want to do things any differently. Marijuana remains illegal under federal law, the Controlled Substances Act, where even the smallest amount of marijuana possession, let alone sale, is illegal. And we're under the concept of dual sovereignty, where the supremacy clause, where the federal law can be applied. And until that changes, until the federal government amends that law or otherwise decides not to enforce it, marijuana is illegal, and employers have a right to enforce their drug policies. They should take certain steps at this point to make sure that they can take advantage of the federal law should they choose.
And second, say this legalization does go unchecked by the federal government for at least a period of time. What advice would you have for employers as far as precautions go?
Okay. Well, again, even if the law stands and federal law remains as it is, marijuana is an illegal drug. So at a minimum, there's going to be a lot of employee confusion as well as potential employer confusion. And employers may have situations where employees who have been subject to drug testing policies before may now think that they can smoke or otherwise partake in marijuana at home and go to work. And that may not be the case. So employers should talk to their employees, remind them of their drug testing policies to avoid that type of confusion. They should have a good written drug testing policy that covers illegal drugs under both federal and state law, so that they've covered the entire gamut. They should prohibit any detectable amount as opposed to being under the influence. In that way, they'll have put everyone on notice. And in particular, employers with multiple locations, whether within the state of Washington or in and outside of Washington, they should make sure that their human resources personnel know how to deal with these issues going forward so that there's consistency. For employers who went through the medical marijuana situation, which was settled by the Roe v. Teletech case in 2011, which was actually a case that I handled, they've been through this before as to how to treat marijuana issues, and it's really the same analysis. If they want to accommodate its use, if they're willing to take certain risks that go along with the potential federal law violations, then they can do so. If they want to accommodate medical marijuana, they can do so. But we have to remember there's valid reasons for employers to have these policies, whether it's safety, efficiency, productivity, health and absenteeism, third-party liability, whether it's a coworker or the employee who is under the influence or using marijuana themselves who gets hurt, or a third party who gets hurt. There's government contracting requirements, government regulations like there are for truck drivers, customer contracts, insurance premium reduction issues. There's a whole lot of valid reasons for employers to have and to enforce a zero-tolerance drug testing policy.
Again, that was Jim Shore, author of Stoel, Rives, World of Employment. For more of his insight, be sure to visit StoelRivesWorldOfEmployment.com. And for curated commentary from the LexBlog Network's thousands of authors, visit us at lxbn.com. Thank you, Jim.
Thank you.